Welcome, everybody. As you know, this year is special in that we have the unfortunate one-year anniversary of COVID to consider. And I think it isn't overdoing it when we are saying that this has changed the world of M&A on its head. The way how M&A transactions are conducted, the transactions themselves, and how everything is run has been drastically altered. We have new types of transactions. We have special purpose acquisition companies now. We have partnerships and restructurings that are much more prevalent than the previous buy and sell side due diligences. And also, since the way that physical meetings have become impossible due to COVID, it is a much different decision-making process actually in the course of many due diligences. Finally, we see that many investors are looking at either new types of targets, basically investing in tech companies to reflect the brave new virtual world, or they are looking at previously solid companies on the market that have found themselves in dire straits financially due to the crisis. I think it's fair to say that just talking about this could fill one evening, but we will just limit ourselves in the interest of time to just a brief overview on the state of M&A regarding employment issues. And here to help with that, I would like to introduce you to my colleagues. We have, first of all, Lee Nair from Lewis Silkin in the UK, who will give you a brief overview on how due diligence's trends have affected the entire process. We have Guillaume Baudier from Capstan in France, who will talk about the process that goes along with the due diligence. And finally, we have Javier Alonso de Arminio Rodriguez, who will deal with the aftermath of a transaction and everything that happens with harmonizing working conditions. I will get you kicked off with brief considerations that deal with the structure of a deal and how that shapes the following employment questions. Annie, if you could. Thank you very much. So, first things first, when you're looking at an M&A transaction from an employment perspective, the deal structure is a very important consideration. If you're considering a share deal, then you're always acquiring the target with all rights, all obligations that come along with it, and there's no way to really shape what you're acquiring. In all of our jurisdictions, we can say that this is not a case of TUPE and ARD. You could have theoretically TUPE implications if you do some sort of post-deal merger or restructuring, but the share deal itself will not be a TUPE case. It's always important to consider that a share deal does trigger information and consultation rights in all jurisdictions to varying extents. And I think that France is very special in that regard. And Guillaume can maybe say a few words about that, because in France, the question of who is the purchaser and who is the seller and whether they are foreign or local entities actually plays quite a big role. And the information and consultation rights vary drastically.
Yes, it's true, because in French law provides that in companies with 50 or more employees, the Works Council must be consulted in the event of a change of control or the sale of the French legal entity. So as soon as a French legal entity which change ownership or will sell the assets of the French legal entities, then the Works Council must be consulted. And one thing which is really important is that under French law, consultation means that the Works Council must issue an opinion prior to any binding agreement is signed by the buyer and the seller. So it's really important to make this consultation process prior to the signature of any binding agreements. But because I just said that the consultation only applies if there is a sale of the French legal entity, it means that if it is we are talking about the sale of the parent company, especially in global deals, in such a case, the French legal entity would not change ownership, and in such a case, no consultation would apply in France. So it's really important to have a clear view on the structure of the deal.
And if you're now considering that share deals are a bad idea in France, then maybe you would consider using asset deals instead. The advantage of asset deals, of course, being that you can pick and choose basically which assets you want to acquire. As a result, however, you always have the downside of having to deal with the question of whether something is a 2P case or not. And that's quite easy when you're acquiring machinery or raw materials and businesses that are asset heavy. But if you have an asset light business transfer, that's problematic if you're just basically transferring the workforce and the expertise that they have. And I understand from Javier that, especially in Spain, there's a very strict interpretation of those rules.
We do, thank you, Till. We do have a very strict construction of European case law on the matter, so we don't have any service provision change regulation or the like. So this means that anytime you have a transfer of a company which is asset light, you have to discuss really well whether assets are relevant or not in the company, and if they're not, transfer of undertaking will only take place in case there is a substantial transfer of employees, and this can happen either because the acquirer is interested in certain employees, either a big amount of them or very relevant employees, the managers, key salespeople, or the like, or because there is a collective bargaining agreement obliging the acquirer or the new service provider to assume part of the staff. So that's a bit tricky, because depending on whether the service that you're transferring is asset light or not, these CBA provisions would imply a TUPE, a transfer of undertaking, or not, because if you are obliged to assume some employees of the previous service provider, for example, and you can evidence that this is an asset heavy business, then you are only transferring employees due to the application of the CBA, and the terms are only those of the CBA. Otherwise, if it's an asset light business, then you are in a transfer of undertaking situation, and you will have to assume the full staff and all the working conditions.
Thank you, Javier. Also, when you're dealing with asset deals, the problem always arises, and it's especially relevant in France and in Germany, whether you have correctly assigned the employees to the economic unit that might transfer. So there is a point where, for example, an employee is servicing different parts of a business and has never been properly assigned to that. And then only at short notice, right before the deal, you decide to assign them to one side or the other, or you don't do anything at all. And you may be familiar with the ECJ case of last year, which was a Belgian case, and that essentially led to somebody being transferred or TUPE'd into a split employment relationship because they were servicing two potential businesses. And so it was unclear if the result was two part-time employment relationships, basically resulting from one full-time relationship. That, of course, opens up all kinds of questions, and whether that is really the end of the discussion will remain to be seen. However, we would just like to stress the importance at this time of being able to, when planning a deal, when structuring a deal in advance, to properly assigning employees with a specific lead-up period. At least from a German perspective, I don't know about you, Guillaume, that would be a situation where you say the more lead-up time you have, the more safely you could assign employees to one side or the other. And if they actually then work for a specific period of time on one side of the business or another, then the chances are high that they will be assigned correctly to that business.
Yeah, that's correct. That's correct. And we have the same concept in France. Of course, the employee should not be assigned too close from the date of the transfer. Otherwise, it would be seen as a tactic to try to keep some employees, or on the reverse, to transfer employees who are not really dedicated to the business.
Great. Of course, with an asset deal, you also have information and consultation rights, so you will never get out of those, but they work slightly differently in each case. We would also like to point out the importance of looking at pension schemes. Of course, that drastically varies depending what type of scheme you have in place, what jurisdiction you're under, etc. But as a general principle, the question is always, when you acquire specific assets and that triggers a TUPE and employees transfer, and you have an employer-financed pension scheme, which is based on accruals, will those accruals also be transferred? It's always a very important point to consider that as part of the asset purchase agreement in that case. Or another issue where the employer is a member of a specific pension fund, but the statutes of that pension fund do not allow the acquirer to become a member of that pension fund, then you always have to reflect that also in the agreement and try to find some sort of solution for that. We will just go briefly in a few specific structured deals. Mergers, of course, in general, they would trigger 2P obligations. There are specific modifications to the general 2P rules, at least in Germany, and that employees wouldn't have a right to object, but instead they could terminate if their previous employer ceases to exist. But the general principle remains the same. Where you have cross-border measures, then you will always need to take into account whether there's a European Workers' Council or a similar body that needs to be involved, that needs to be consulted and informed early on. And there are also specific rules that apply when you're acquiring a business that has become insolvent, or is under liquidation, under administration. The 2P rules are typically modified in each of the countries. And finally, if you're issuing a takeover bid for a listed company, then there are some specific information consultation requirements there too as well in all of our jurisdictions. That's just a high-level picture about the deal structure. I would maybe like to round that off with a few questions to my fellow panelists. I think there's also been a Q&A on one point, so I will just start with that. So there was a question in France if there's a requirement for the purchaser to consult their works council if the purchasing entity is the France entity. And if so, does this need to be done before a put option agreement or a share purchase agreement is entered into?
Yeah, it's a very good question, because indeed there is an obligation not only for the seller to consult the works council of the target company, but also for the buyer, which intends to acquire a business. Of course, if the buying entity is a French legal entity which has a works council, the works council of the buyer of the potential buyer should also be consulted prior to the signature of any binding agreement, which means that if we have two French legal entities involved with each of them having their works council, both of them will have to consult prior to the signature of the share purchase agreement. So in practice, if both of the companies have to consult their works council, usually, and we see that in the communication issued by the companies, that the parties have entered into exclusive discussions. Usually for us, it means that the deal is done. But for a works council point of view, labor unions and media point of view, the parties say that they have decided to enter into exclusive discussions, which means that the deal is done, but we will start now the consultation. And once the works council will have issued their opinions, then the parties will sign the agreement. But usually the agreement has been negotiated, highly negotiated during months and weeks. And finally, after this exclusivity period, then the parties, after having obtained the opinion of the works council, would sign the binding agreements. If only the seller has to consult, because, for instance, the buyer would be a foreign company without any obligation, then the potential buyer would typically issue a put option agreement, so a binding offer for the buyer, but not for the seller, and the seller would only accept the offer once the works council of the French legal entity will have been consulted.
Thank you very much, Guillaume. Lee, maybe just as a general idea for our audience, what would be, from a best practice perspective, some provisions that you would recommend to have included in a share or asset purchase agreement, respectively?
Yeah, sure. So, I mean, the thing they have in common is that they're both going to have sets of warranties and possibly indemnities if there's areas of particular risk. So the warranties need to kind of capture all the relevant areas of employment law to trigger out any kind of further flushing out of important information through the seller's disclosure letter. So a buyer needs to have certainty over things like which employees are being taken on, where they're in, what terms they're employed under, where exactly they're sitting in an entity, and things like that. So those are the key areas for warranties. Where 2P applies under an asset purchase scenario, the agreement should contain more kind of tailored 2P specific provisions. So in the UK, it's pretty common to have a schedule that lists all of the employees who are thought to work mainly or wholly in the business to avoid ambiguity over who's going to transfer. There's often provisions dealing with kind of apportionment of 2P liabilities. So the general line is that the seller is responsible for liabilities that relate to the period pre-completion, and the buyer is responsible for anything post-completion. And sometimes you see clauses as well on kind of how the parties will cooperate and work together during the 2P information and consultation process. So that could be things like the seller assisting with any process to kind of get employees signed up to settlement agreements if you're going down that route, or the buyer being permitted to attend a certain number of consultation meetings, say. Indemnities in an asset purchase scenario typically will address kind of unintended transferring employees, so surprise employees who you didn't think you were going to get, and failure to inform and consult on both sides. So yeah, asset purchase agreements pretty tailored to reflect those workings of 2P.
Thank you, Lee. Javier, I recall that earlier on you said it's difficult in Spain to deal with those types of businesses where you have only immaterial assets which are transferred. How would you deal with that in practice?
How we handle? I mean, we basically you discuss which type of scenario you are in, whether the companies were supposed to have certain assets, whether the services need to have premises to do that. You tend to give some value to software and computers and this sort of immaterial assets. But at the end of the day, that's a very gray area. So it has to be analyzed on a case-by-case basis and really consult which is the case law at that point of time. Because, for example, we used to have a very solid idea that call centers were an asset-intensive business, for example, and that was accepted by the Supreme Court. But there are already certain judges of the Supreme Court saying that they are willing to receive again a case on this CVA to discuss that conclusion. So it's really changing a lot, and it's always important to consult which is the case law at the moment, which is the ideas of the judges in the Supreme Court at the moment. So it's very important to check everything, the development, and it's very important basically because if you fail to detect a transfer of undertaking in Spain, situation can be very complicated because if the company that should have assumed the employees does not do so, it can face a collective dismissal claim, and a collective dismissal which has not followed the mandatory procedure is a null and void dismissal. So this means you have to reinstate employees, which will be protected against retaliation for some period of time. So even if you sign warranties and indemnities in the agreement to try to cover the situation, it tends to be very complicated in practice because you cannot get really the employees dismissed. So the indemnities that have to be paid are very complex.
Great, thank you. So that would conclude our first segment, and I will hand over to Lee, I think, for the next step.
Thanks, Till. Yeah, so our next section is due diligence, and I think I'm lucky to have got this topic because that basically means finding out all the secrets about what you're buying. So it's surely the most exciting part, and it drives so much of the rest of the process. So from negotiations around what is going in that purchase agreement to planning for the future, what you're going to do with employees once the deal is done. A lot about the process of due diligence is similar across the kind of countries represented here today. So we've all experienced the downturn in the M&A market at the start of lockdown 1 and a considerable uptick, which has led to some really speedy transactions actually, especially in Germany with a much shorter time frame for getting DD done. So you need to focus on the really important things when you don't have time on your side. You're looking for the big ticket items. So are there any red flags that are likely to cause you problems down the line or to impact the value of the business that you're buying? And of course, if it's an asset purchase situation and 2P does apply, then you could expect to spend a bit more time thinking about what's a contractual entitlement and what is just discretionary and easier for a buyer to change once the deal is done. So employee benefits and bonus schemes are pretty big areas of focus there. In terms of what exactly we're looking for in the due diligence process, there's commonalities and differences across each of the countries here today, as you might expect, but some of the more interesting ones from our discussions. In France, there's a particular focus on working time arrangements because working time is highly regulated, I think known for that, in France, and overtime has to be paid. So the biggest risk is around executive employees, and the risk of a claim for paid overtime needs to be addressed adequately through appropriate warranties and representations in the purchase documentation. Disguised employment is another hot topic across all of our countries. So but by disguised employment, we of course mean where an individual is engaged as a contractor in name, but in practice is being treated like an employee, which gives rise to employment rights arising. So there could be claims off the back of that, like unfair dismissal, paid holiday, and there's tax and social security risks as well. And those can be really costly. So in Spain, for example, an extra 30% can be added to that sum due, and then the company can be fined anywhere between that new sum and 150% of that sum. So if you imagine that multiplied by however many people plus interest, then that's a pretty hefty liability to pick up on. Another big thing to check is around change of control provisions, and however you want to call them, so kind of golden parachutes or some sort of payments that employees can receive if a business is acquired, particularly senior employees. So you want to check those kind of exec contracts. And obviously you need to make sure the contract itself, the employment contract, is fit for purpose, and things like notice period and post-employment restrictions are really important. And as a general rule, enforceability of restrictions depends on whether they're proportionate. So beware restrictions that last for years and that are really broadly drafted, because there's a risk of taking on a workforce which doesn't have effective restrictions. In the UK, the restricted period can be unpaid, generally is unpaid. It's rare to see anything but that. But elsewhere, you need to pay throughout. So in France, you're generally looking at around 40 to 60%. In Germany, it's 50%. And in Spain, I understand there's no prescribed amount, but 70% is about the right sort of ballpark. So that's something to check. Collective bargaining in the UK is not a massive issue when we're doing due diligence, actually, but is a huge issue elsewhere, obviously. So a good relationship with those collective bodies can have such a big impact on getting the deal done. In Germany, since COVID-19 has struck, the unions have really been pushing harder for long-term job security, forcing kind of negotiations on job safety pacts, which are going up to 2025, even beyond that. And works councils as well are negotiating agreements, insisting on agreements which will make redundancies and restructurings much more difficult. So those are things to check out for. And in terms of COVID, there's been changes in the issues that we need to look for. So, for example, all of the countries represented here today have had the benefit of some sort of state support scheme. So the terms on which employers are permitted to access that is something to understand, to check that that's been done properly. In France, the government has strongly encouraged businesses to use short-time working. So that is something else that may become apparent through due diligence. A really quick word before we have a bit of a panel discussion on data protection in light of GDPR. So in a corporate transaction, the data is shared on a controller-to-controller basis. So a data processing agreement isn't mandatory under GDPR, but it would obviously make sense and be a good idea for the seller to impose some sort of restriction on a buyer so that they can only use the data for assessing the business for purchase. And a seller should also think as well about practical issues like what to do in the event of a data breach and plan for that at the start. So it'd be really good to hear from everyone else on our panel about their experiences in the area of DD. Till, can I start with you? My question is around a buyer's influence. So how can a buyer have influence on collective negotiations which are taking place before signing, but which might have actually a really big impact on the wish to make any future restructures?
Thank you, Lee. Well, I think there's no one recipe that you could follow, but what you need to take into account is that such discussions, such negotiations may be going on at the time you become first involved in the negotiation process. And that's why it's always important to figure out if there are such discussions, then you should have a seat at the table and you should have an influence on what potential giveaways or what potential, let's say, job security rules you could agree to because they don't limit your business model, and which are deal killers effectively for you, because it doesn't pay off if you conduct the due diligence and everything is due and proper, but in the end you get some sort of agreement, short notice, one day before the deal is signed, and that basically says you can't do anything after you've purchased the target.
That wouldn't be fun at all. I know you do a lot of work with technology-driven businesses, don't you? In your experience, what kind of specific considerations are there when buying or selling that type of business, especially kind of in a world of remote working due to COVID?
Yeah, I think one of the main points you need to take into account would be that most tech-based companies have an increasingly virtualized organization anyway. They use remote working of all kinds. And so what's always worth checking out is what is the legal basis for that remote working? Has it been properly set up? What about data privacy, data security, confidentiality rules? Are employees actually allowed to work from home? Because in most cases, residential addresses don't allow for commercial use, etc. So you just want to make sure that the way the business has been set up would withstand any authority audits as well.
Thanks, Jill. That's really interesting. Guillaume, I understand that in France, it's a bit of a buyer's market at the moment, and buyers are looking for greater and longer guarantees. What tactics have you seen that sellers are using to try and limit these guarantees?
Yes. So first, one thing which is important is that the due diligence process is now conducted in a very short period of time. So we've seen, for example, last December, we were contacted on the 5th of December by one of the major listed French companies which wanted to acquire a German subsidiary of a German large group. And the deal was done in almost 3 weeks with more than 1,000 employees. And the due diligence was conducted in about 10 to 15 days. So we've seen the due diligence period really reduced dramatically compared with the past. And in this very short time frame, now the tactic that the seller try to use is to include in the reps and warranties provisions of the share purchase agreement some caps on the warranties, which means that they say that they will only indemnify the buyer if up to a certain limit, and the limit is always they try to reduce the limit as the cap as much as possible. So there can be several caps, for instance, special cap for tax matters, special caps for employment matters, but always caps. Caps have been are now usually the trend. One thing we've seen also is a general statement under which all the information disclosed in the data room will not trigger any claim for indemnification. So it means that not only you have to work on the due diligence for a very short period of time, but everything which was disclosed in the data room would be considered as an exclusion from any liability for the seller. And we've seen also a tactic where, due to this general statement, then what happens is that at the beginning of the when the data room is open, we have only very little information, and 1 or 2 days before the data room is closed, we see a lot of information included in the data room, so that it will be very difficult for the lawyers to be able to check everything. Whereas everything which has been disclosed in the data room would be excluded from any indemnification for the buyer. So that's what we see currently.
Oh, I've definitely been in that situation. I'm sure we all have. Javier, I spoke about the different red flag issues that can come up in due diligence. In Spain, in your experience, have any employment issues uncovered during the due diligence process proven to be a real deal breaker?
Yeah, well, basically there's two types of cases in which I have found employment matters to be deal breakers. One is if the big contingencies in amounts, but basically not so much due to the amount, but for the impossibility to give a figure of which is the risk involved. So the moment in which you say it's not really possible to explain how much money we're talking about. And this is especially a case when there's health and safety issues, big health and safety issues. So we have a very strict regulation on this sense. So if there is a work accident or a professional illness, and it's proof that the employer had not duly complied with all health and safety obligations, there won't be only a fine plus damages, but also the employer will become directly liable of a surcharge to the public pension. So basically, the public pensions awarded to the employee or the heirs are increased in a 30 to a 50%, and the employer is obliged to pay the amount, the capitalized amount needed to cover this life pension. In some cases in which the risk can affect a lot of employees, and you don't really know how many employees can be affected, whether employees that worked for a couple of years are affected. Basically, for example, asbestos has been a big issue, being exposed to asbestos. If there's a company in which employees have been exposed to asbestos, usually this is a deal breaker, because the biggest asbestos manufacturers in Spain have become bankrupt due to these health and safety issues. So this is a matter in which the amounts are really big, and you don't really know where you're getting. You don't know if it's 10 employees or it can be 500. You can't know when an employee will develop an illness related to asbestos, and they have a claim that never prescribes. And the other big issues, the other big deal breakers are usually cases in which there is something that impedes the harmonization or restructuring that the purchaser has in mind to enjoy, to the full synergies of the transaction, either this previous collective dismissal with employment obligations to keep employment for certain years, or due to the number of employees of certain age. It's really expensive to go through a collective dismissal. So it's basically that. It's basically either we cannot see which is the risk involved, or we cannot assure that the restructuring that the purchaser had in mind can take place.
That's really interesting. Some pretty massive liabilities lurking there. And just one final question quickly before we move on. In terms of approach to due diligence, do you think the approach differs depending on whether the buyer is an investor or kind of an industry client?
Yeah, in my experience, industry clients tend to focus in the matters which really concerns them, which they know are the usual issues in the day-to-day business. So they tend to focus. I want you to solve, to check this, and this point, and they insist a lot on that. And other than that, they tend to dislike reliance on vendors' due diligence. So this idea, which is this new trend in which an investor say, no, don't do a due diligence. I just want you to check the vendor's due diligence at some point, any big contingency that arises from there. That is something that, in my experience, Spanish industrial clients don't like so much. They really want to know how the business works, how labor relations are handled.
Thanks so much, Javier. And we're going to move on now to Guillaume, I believe, on getting the process right.
Yes, thank you, Lee. Well, in this section, we will discuss the main steps of M&A process and the importance, of course, of getting the process right. We've already addressed some of the issues, but I think that first of all, especially if the acquisition is part of a global deal, coordination is a key aspect for the success of the operations, because you can have a very good process, compliant process in one country, and be totally out of the game in another country, because you would have failed to comply with very significant obligation in other countries. So I think the first point to consider is the timeline of the operation, especially in global deals, and also the various steps that will need to be implemented before the transfer, but also after the transfer, because we will see that in some cases, especially in asset deal, The obligation to consult with the employee representatives depends on the impact of the operations, on the employees' working conditions, on the operational aspects of the business. So depending on the intention of the buyer for the future, it is really important to know what will happen. Of course, we not always know everything about the next steps, but if the buyer has already some ideas about the future and the way the business will be reorganized or maybe consolidated, then it's really important to know that as soon as possible to be able to comply with the obligation. Another thing which is really important is the communication. Communication on the deal must be defined in advance. Of course, it can be adapted along the line, but it should be defined as soon as possible, and it should be consistent with the legal approach, because it's always a challenge for us lawyers when we have a legal process and the communication which is issued by the buyer or the seller is totally different from what is currently contemplated from a legal perspective. Also, something that we have seen is a communication around cost reduction synergies, and cost reduction synergies is something that sounds very bad for the labor unions and the Works Council. I know that for the markets, it sounds very good. It's always important to be able to communicate on cost reduction synergies, but it means that your consultation will be much more complicated, because for the labor unions and the Works Council, it means cost reduction means economic dismissals, collective redundancy, and changes in working conditions. So once the structure of the deal has been defined, is the share deal an asset deal? Is there a need to do a carve-out before the transfer? Then the first step is to clearly identify the local requirements. So we have seen previously, and Till mentioned that in his presentation, that consultation requirements vary by country. It may be necessary to consult the employee representative in some countries, but not in other countries. It may be also necessary to consult with the European Works Council, depending on the provisions of the agreement that established the European Works Council. So all these consultations or information or consultation must be carefully prepared, and the timeline should be very consistent. So as you can see from the table, France is unfortunately one of the countries with the most extensive consultation requirement, because consultation requirements apply in case of share deal or asset deal, except in situations that I mentioned where it's a share deal at the level of the foreign parent company. When in other cases where the French legal entities are involved, consultation apply. In Germany, it depends. On share deal, there's an obligation to consult, but in case of asset deal, it's only in case of operational change. Whereas in the UK and Spain, no obligation to consult apply in case of share deal, but in case of an asset deal, there might be an obligation to consult. In terms of information to be provided to the Works Council, in France, we have a quite extensive obligation to inform the Works Council and discuss with them the reason for the project, of course, to describe the project and the timeline, and mainly to discuss also the impact or potential impact of the acquisition or the sale on the business, the organization, and of course the consequences for the employees. During the consultation process, which can take 1 to 2 months in France, there are a lot of discussions with the Works Council who can raise questions. The management has to answer the questions, and there is also a possibility for the Works Council to appoint an expert to help them analyze the project. I think in the UK, Lee, maybe you can say a few words about the obligation. I understand that there is no works council in many companies, but the obligation to consult when it applies can be with labor unions or with employee representatives, specially elected.
Yeah, that's absolutely right, Guillaume. So it depends on the industry. So, you know, in manufacturing industry, for example, collective engagement is more prevalent, but by and large, the M&A work that I do, there's no kind of union or works council involvement, in which case there's kind of a trickle down effect as to who an employer needs to consult with. You're absolutely right. There might already be a standing body of employee reps who you could consult with if they kind of have the right mandate for the topic in hand. Otherwise, it's a process of letting affected employees choose who amongst themselves will stand as a rep. So they have to be able to kind of put themselves forward if they want. And that's kind of a broad thing, really. Affected isn't just people who are due to be transferred themselves. It's people who might otherwise be impacted in some way, maybe because part of their job will disappear or whatever. So that's kind of the way it works in the UK.
And I think till in Germany, in some cases, you also not only the obligation to consult, but also to seek an agreement with the Works Council on some aspects of the deal.
Exactly. If you have an operational change, then what you need to do is find an agreement or attempt to find an agreement with the Workers' Council before you can implement. If you just try to push on ahead without doing so, the Workers' Council can ask you to cease and desist, and that's what you want to avoid.
Mm-hmm. Okay. Secondly, and maybe we can switch to the next slide. Secondly, and I'm especially talking for France, there are some country specifics that you need to take into account, which can see quite weird in some countries. For instance, in France, in companies with, if the target company is a company with less than 250 employees, the company has the obligation to inform all the employees of the intention to sell the shares of the company or to sell the business of the company, so that the employees can make an offer. So it can be quite weird, especially if you have had discussions with the potential buyers during weeks and months. But before you can sign the agreement, you have to inform the employees so that they can potentially make an offer on the business. To be honest, this obligation has been applied for now maybe 10 years, and I've never seen one case where the employees of the company have made an offer in competition with the offer already received by the company. So that's one of the French specifics. The second one is in relation to antitrust process, because in France, when the antitrust authorities publish the official statement saying that the buyer and the seller have filed an antitrust file to the antitrust authorities, the French company has to convene the Works Council members to inform them, and during this meeting, the Works Council can decide to appoint an expert to assist them. So if the Works Council has already been consulted on the project, it's not really an issue. But when the deal is made at global level, then the French company may have to convene the Works Council to inform them of the antitrust process, and the Works Council will have an opportunity to hire an expert to analyze the process. So it's an additional. It's not really a hurdle, because it usually happens after the agreement has been signed, after the signing of the SPA, but before the closing of the operations. But it can be seen as a formalistic approach, which can be quite burdensome. And I think that in Germany and Spain, there are specific obligations to consider in case of merger or demerger. where you have specific information duties with specific deadlines. And in Spain also the obligation to include some information in the director's report before the merger. And now if we move on to the next topic, which is also very important, is the information of the employees. How and when the employees must be informed. So again, the process, the obligations are different from a country to another. In case of share deal, in general, no requirement, but it is very common for the parties to put out a positive communication on the deal. So the employees, usually there is a communication a stream with a very long list of communication initiatives which are taken. But when you have to deal with 2P transfers, so when the employees will transfer from an employer to another one, then there are usually more information, and the employees must be informed on the 2P transfer in due time, with a timeline which varies from a country to another, especially in countries where the employees have a right to object to the transfer. I think it's the case, I'm pretty sure it's the case in Germany, and specific timelines will apply because of the right for the employees to object to the transfer. So in France and Spain, the transfer is automatic and mandatory, so there is no right for the employees to object to the transfer. Of course, in France, it would be the only exception if the employee could prove that he should not have been transferred because he was not really dedicated to the business. But in other cases, the employees would be automatically transferred, and any objection from the employee would be treated as a dismissal for disciplinary reason by the new employer. So no right to object in France and Spain, whereas in Germany, employees can object within 1 month of receiving complete information. So I think that you have, in Germany, you have to send very detailed information so that the employees can make that decision, a duly informed decision. And in the UK, also a right for the employees to object at any time prior to the transfer. But I think that the difference between Germany and the UK is that in Germany, if the employee objects to the transfer, he remains employed by his previous or his current employer, whereas in the UK, that would be treated as a termination by the employee. So that's a major difference, because in Germany, then it means that the previous employer or the current employer would have to make redundant. We have to make the employee redundant if he doesn't have any job to offer to the employee. Dismissals before a 2P transfer can be an issue, because it happens that the buyer says that he's not interested in all the employees, or he would like the seller to make some employees redundant before the 2P transfer. In France, for instance, such dismissal would be considered null and void, and the seller would not be able to dismiss the employees before a 2P transfer, unless he would have the employer would have a totally different reason than the transfer, for instance, economic difficulties. But usually the period before the transfer is really a gray zone, where we would usually consider that any dismissal could be declared null and void. And last but not least, the protected employees. In France, it requires specific authorization from the labor inspector. So maybe one question, because I think that we will probably run out of time. Maybe concerning Germany, till we know that unions are important in Germany, but at the same time, there is no specific obligation to consult with the labor union. So what is exactly their role in the process?
Yes, I mean, basically, the unions can have consultation rights if they are provided with such under a collective bargaining agreement, but not under the law itself. The point is that unions could get involved into at least large-scale restructurings or large-scale sale activities and try to negotiate a social plan in excess of the social plan that the Works Council negotiates. And you can also have some sort of the parties negotiating themselves upwards and upwards. And that's a situation you want to avoid. You don't want to get between the union and the Workers' Council trying to find the best solution for their respective in-scope employees.
Okay, so I think we can move on to the last topic.
Thank you, Jon. The last topic, we're going to go very fast through it because I think some of the topics we've already mentioned. We're basically going to discuss how does the M&A process we have followed impact in the possibilities to restructure or harmonize working conditions after the transfer. Very generally, a third deal does not affect the restructuring or harmonization options. This doesn't mean that those are easy. It means that those are the general procedures and costs provided by law, and that the existence of the transaction does not include any additional restriction to these procedures or doesn't impact them. There's a couple of exceptions. In Germany, even in case of a third deal, the transaction could result in a change of the applicable collective agreement, and that can have some indirect impact on the procedures or the restrictions to implement certain redundancies. And in Spain, there are certain causes and procedures that are referred to the group of companies, to the mercantile group of companies, and therefore the mere change of the shareholder does impact the possibilities in certain occasions. For example, economic causes in Spain have to be present in the group of companies, in the Spanish group of companies. So even a third deal has an impact because it will change the overall results of the group, and you could end up losing an economic cost that you had in a former group. You lose it when you get it into a more profitable group, and you have to find a different type of reason to justify your redundancies. And we also have what we call a special economic contribution, which is payable in all collective dismissals that affect employees of 50 years or older in a significant percentage. And in these cases, the dismissals done in the group of companies and the employees of 50 years or older in the group of companies have certain impacts. So there are certain indirect impacts, but just indirect in both cases. While in case of an asset deal, there is a big impact in the possibilities to restructure, to harmonize the working conditions, because there's a general principle of an obligation to respect the employment terms and the employments itself. So this means, regarding redundancies, as Guillaume already mentioned, that the transfer of undertaken cannot be rational for the dismissals itself, and if it is used as the rationale, this would lead to the dismissals to be considered unfair. In case in the UK, automatically unfair, which leads to the pay of a special compensation. Or in Germany, Spain, and France, this will lead to the dismissals to be null and void. Generally, this implies that companies are obliged to reinstate the employees and pay the salaries accrued from termination and up to restatement. And in some cases, that could also oblige to the payment of some damages. As on the other hand, it is possible to implement redundancies after the transfer, but it is necessary to have sound business rationale that are not related to the transfer itself. As an exception, in Germany, there's a possibility to implement the redundancies before the transfer. In case you use the figure of the purchaser's concept, which still I think is a very interesting concept, because I think it avoids trying to hide the existence of business reasons before the transfer, which we tend to do in other countries. And it sounds to me very interesting that you have this option in Germany. I don't know if you might explain it in a couple of minutes.
Yeah, sure. Just a few brief words on that. So the purchaser's concept is basically in a situation where the purchaser knows that they will have a different organization in place that will lead to redundancies. Then the German law says that there's no requirement to wait for the transfer to be executed and then run into the eventual redundancy situation, but rather the purchaser and the seller can agree in the asset purchase agreement that there is a specific, let's call it, staffing level that the purchaser requires, and the seller can then use that purchaser's concept as a justification for operationally motivated dismissals.
That's really interesting. I think it's good to see how things are done in other countries, because that's something to learn in Spain. This idea of being obliged to respect the employment terms obviously also impacts the possibility to change working conditions. Again, in general, all jurisdictions in an asset deal will accept the possibility to change working conditions post-transfer, after the transfer, and provided there are separate economic, technical, or organizational reasons, and obviously all mandatory consultations procedures are followed. In most of the countries, this is obliged to have an agreement with the employees. This is not the case in the UK, in case the employment contract already provides the possibility to change these working conditions without the need to reach a specific agreement when they're changed. So the idea is, if these were the terms you agree with your employer, as the new employer is surrogating in the position of the seller, all the terms, including this provision, will apply. In Spain, agreement is no required. So if you can, or the employer can evidence the existence of sound business reason and has respected the procedure, if no agreement is reached during the consultation process, it can directly implement the change in working conditions, even salary. However, obviously, this is subject to further claims and to judicial control. Okay. And finally, we are in COVID time, as Till said, and this has had an impact in restructuring in some countries. I think that everyone knows that, for example, Italy has limited the dismissals during a COVID-19 situation. There are also some limitations in Spain and Germany. In Spain, we have a very unclear reference in the law saying that all dismissals related to COVID-19 will be considered unjustified. So it's not clear if those are prohibited and therefore null and void, or just unfair. Most of the judgments tend to think this should be construed as a decision of the lawmaker to state that these dismissals are unfair, because there is a need to do a restrictive interpretation of the null and void clauses. And there's also some limits derived from the impact that has to change from a reduction of working time scheme to redundancies. That is a case in Spain, and I think it's also in Germany till that there will be difficulties to try to justify that the same causes that justify only a working time reduction in the past now justify redundancies. Thank you everybody. I'm afraid we are running out of time. Time goes very fast when one is having fun. And Annie, if you want to say some words to close the webinar.
Yes, thank you, Javier. So we have now reached the end of the presentation, but I would like to just say that for any further questions, the panelists will remain available by email, and that you can find their contact details in the follow-up email that you will receive by tomorrow. And for more information about today's topic, as well as other topics, I advise you to check out our website, where you'll find several interesting resources and articles on global HR law issues. And for more information on our webinars and podcasts as well, you can visit the event section of our website, where we keep all the past recordings. So finally, I would like to thank everyone for attending today, and thanks also to our panelists for their insights. So with that, this webinar will now be ending. Thank you all.